had the option of doing that in a rule and did not.
That makes sense. And this is Sarah again. As we're talking about this raises another concern for me, which is, and I'm sorry, I know we're trying to finalize things, but we're seeing a lawyer violates paragraph D in a comment. And so that just doesn't seem right to me to have. I don't think comments generally say a lawyer violates by this. That seems to be going beyond a mere comment and providing guidance.
May violate?
We actually, 1.8.2 does say a lawyer violates that comment.
Oh, it does. Okay.
The use of client information, and it says that you violate your duty of loyalty by using it.
Okay.
To the disadvantage of a current client.
All right. It just seems inconsistent with.
It's the only other place.
Okay.
Is it? This is Cassidy. I mean, we're trying to give some meaning to prejudicial to the administration of justice. So I think the may might be appropriate there because civility is not the only way that you can prejudice the administration of justice,
Now
right?
it gets awkward as a stand when we're saying it may violate the rule if you engage in significantly unprofessional conduct.
It may not.
Yeah. And this is Sarah. I was considering alternatively saying something like conduct prejudicial to the administration of justice may include,
There you go.
but I don't know that it
Includes.
Well, this is Dan, I like that because in the
Without
past, I
limitation.
looked at that subsection D and thought that it does not prohibit these egregious activities.
This is.
That would help, I think.
Sorry, Dan, go ahead. This is Hunter. One of the things that we keep kind of dancing around is that incivility is like obscenity.
Yes.
You know it when you see it,
Right.
right? And trying to define it before it happens is difficult. By saying it may include or it may, by giving that, you're essentially giving whoever's reviewing it some level of context where they can say, I know it when I see it, and therefore it falls under the rule. But it also gives them the option of saying, I see how that can be construed this way, but that's not what that says.
Yeah.
Can I mention something? I know you guys are thinking of putting in a lawyer should consult and insert civility guidelines. You guys are aware that the local courts have their own as well, right? Or local bar associations have theirs as well. I guess also the district courts also have their own. Would we only refer to the California guidelines or would we refer to other ones as well? I'm just curious.
Oh,
You could say
civility guidelines.
consult the California blah, 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 and other civility guidelines.
Yeah, because I know the district court have their, well,
Applicable, yeah, applicable.
Any applicable civility guidelines.
In your jurisdiction. Sorry.
Well,
I'm just
Justin doesn't
mentioning.
like.
Now I'm thinking of something any guidelines that may be applicable.
I know,
Um,
this is so crazy.
Angela, would you mind pulling up the current comment 6 to 8.4? Yeah, thank you. So I was just thinking of that, whatever it was, see you next Tuesday comment that got all the news. And, technically that was not a repeated engagement in incivility, but I think we would agree that it violates Rule 8.4. And so I don't think we want to suggest that it's only repeated acts of incivility that might necessarily violate a rule of procedure or evidence, right? That happened outside of the hearing, after the hearing, right? So somebody made a suggestion about using the term includes, that these are examples of violations. It's not exhaustive. Might be appropriate because there certainly are instances where a singular act of incivility should warrant discipline, right? Like that egregious example, that real world example. And again, of course, this, I don't want to spin around here, but to the point that Hunter was making, incivility it's probably too general. I mean, it's really what we're talking about, again, sticking with this real world example, is conduct that was abusive and harassing, right? And that alone warranted discipline. Just because you're uncivil doesn't mean that you should be disciplined, even if you're just repeatedly just not a civil person. It's not, because that's really, it's like a misnomer, this whole task force, right? It's about people who are abusive and harassing and threatening and discriminatory, and we're trying to curb that conduct, not people who are just rude. That's my take on it. So a long way of saying I do think maybe we want to consider that includes language here, so that we're giving examples of violations rather than suggesting that these are the three primary examples of violating 8.4, because I think historically 8.4 has been used by the courts pretty broadly. So I don't think we want to inadvertently narrow its interpretation with this formulation.
So,
This is Joel. What I'm gleaning from this conversation is maybe we gotta just come out and in the comment, admit that servility is a term that is not capable of precise definition. And therefore, for additional guidance, see all these other civility guidelines that we've been talking about.
What's the whole point of it?
Erica, can you go back down for a second? So could it be a lawyer violates paragraph D by engaging in significantly unprofessional conduct that includes abusive or harassing, we're missing a word there. Some abusive or harassing something,
Conduct?
conduct. So it'd be that includes abusive or harassing. Does that allow for, Justin, what you were saying? That
No,
it's non-exhaustive?
No, the non-exhaustive piece would be up at the top if you go to the top of 6, because right here we're saying that it violates D if you're repeatedly engaging in civility. But my point is, you could violate D by just one instance of incivility. It doesn't have to be repeatedly. So it could be an example of a violation of D if you were repeatedly engaging in incivility. But we want to make sure courts still have the flexibility to, or disciplinary bodies to say you've violated the rule by a singular act of incivility, like the example that I gave.
I think, depending upon if it's this language or the language below, I think the thought with the language below was to remove the word incivility, to just use what was in the terminology.
And did we,
So
this
here-
is going to replace what I was just reading from?
Yes.
Then never mind.
Okay.
Yeah, I was getting confused.
Okay, yeah, so this would replace,
Okay.
this would be 6.
I'm good.
Because, and then I think with that includes, it's no longer exhaustive.
Perfect. All right. Ignore everything I just said and more.
But I'm glad you said it, because now I understand.
This is Sarah, though. I think that changes the meaning by saying that includes here where we put it, because it's significantly unprofessional conduct that is abusive or harassing.
Sure.
So
No, I'm fine with
right, because we're going back to.
So I think we should tweak it a different way, perhaps. And initially, and I'm not suggesting this, we had talked about maybe saying conduct that is prejudicial to the administration of justice includes engaging in significant.
That's the same thing.
Yeah. That is abusive or harassing.
It include, right, because what you're trying to say is that there's other conduct that can violate that can fall
Or
under D.
or we could make it even shorter, I guess, and just say, instead of lawyer violates, just say paragraph D includes.
Violations of paragraph D include.
Yeah. Sections of paragraph D include without limitation.
Engaging in.
Just get rid of this whole thing, Sarah.
I think we keep it in, but we just say includes engaging in significantly unprofessional conduct that is abusive or harassing. So get rid of by. Yeah.
Yeah, deleting what's there. Yes.
Oh, wait, violations would include, not includes, but anyway.
I like a violation of paragraph D includes. But, because why do you make it plural?
Yeah.
And then
Violations.
we have two engagings. I think we have to say include significantly unprofessional conduct that is abusive or harassing. So I propose we delete engaging in the second one, not the first one. Yeah. And then I propose we delete conduct after harassing.
Is the conduct comes before.
Right.
And then I can't see, my vision isn't great, but I don't, this is Sarah, I think we could, just this minor, but do we delete the comment? Is there a comma after abusive or maybe not? I think that should be deleted.
Looks like there is. That should be.
The first violation should be C.
Yeah, it's a violation.
Yeah.
And then, this is Sarah again, I think we should delete by, second by. Or now the first one. That's right.
It's defined in discriminatory practice of law means.
So how do you all feel about, this is Justin, how do you feel about this intentionally violating established rules of both procedure or evidence? Do you feel like that's getting to the part of the concern of incivility, or is this a different issue, or is it too vague, or is it just right?
Justin, this is Sarah, and I raised this previously, and I am not in favor of that language. I know that the working group, and I think we've talked about it perhaps at one of the other co-part meetings, had concerns about that language. And I think it was, Bill also pointed out too, that it's something that the judge can curb that type of conduct. There's other remedies for violating rules of procedure or evidence. So I would propose that we strike it, but I'll pause because then others weigh in.
This is Hunter. The reason why I didn't have a problem with it is because not the next sentence, which was from comment 4 up in definitions, but the next one, which is a lawyer does not violate this by. I was fine with it, given that we have that caveat that we're not just talking about, hey, you violated, you shouldn't have objected when you felt like you should have. But I've definitely been in situations where attorneys are essentially just throwing the judge's commands to the wind and saying, no, I'm just going to do what I want to do. And I feel like having some teeth in there with that caveat, I think strikes the balance. But you might want to put them together so that the second sentence would be a lawyer does not violate paragraph D by. And the third sentence would be this does not apply to conduct protected.
This is Dan. I would be in favor of taking it out because I'm reading that and saying anytime that a judge imposes a discovery sanction would fit in that language.
Oh, yeah.
So
You know,
That's a good point.
there are reasons that happens, but it's always an intentional violation of established rule of procedure.
And I also, this is Sarah, I also think for purposes of discipline, it's could be very hard to determine. I mean, I guess if there's an order in the Superior Court, but it's hard to determine what's intentional or whether it was just the attorney's ignorance and not knowing the rule.
Yeah.
Yeah.
It must be intentional.
Yeah, I know.
But yeah, I mean, I can say, I that's well taken. I just have, if you're just, not routinely, but if you're sanctioned for a discovery violation, that's and then you risk it a disciplinary, like opposing counsel is going to report to you every time. And then the investigator looks at this and says, oh, we're going to send you a letter, I mean,
What's the defense? There's the order, you're sanctioned.
right.
I think that's to your point. It's a court of regulatory, judges deal.
That makes sense.
That's Elizabeth, and you can get sanctioned for discovery abuses that you had were absolutely not your fault. Maybe they only moved for sanctions against you and the client didn't comply with your 20,000 request to turn over this, that, or the other. And whether you're sanctioned doesn't necessarily establish that you really did anything wrong.
When you do
That's a great
something
point.
wrong is after you're sanctioned and you don't tell the client, you don't, like that's where the ethical violations arise. It shouldn't be with the discovery sanction. It's like,
There are some discovery sanctions that judges refer to the
Yeah.
disciplinary process anyway.
Yeah, right.
And that's within the judge's discretion.
right.
So I would,
Well, that's why I kind of, I think, preferred sort of a standalone, because the rules that particularly apply to courts should be addressed in the ethical rules that specifically apply to courts. But, and then every judge has a limit. They might allow 4 times when you misuse the evidence code, but not the 5th, or maybe 3 times and not the 4th. But the point is, outside of all that, whatever the judge may do, you just shouldn't be engaging in that kind of harassing conduct. And so that's why I kind of wanted to take this all out and put it into the bucket of, and by the way, just don't be a jerk, and here's what you're not supposed to do. So, but that's where I kind of lose this whole conversation, and I get into getting lost in what we've already covered and not covered. But anyway, that's just my gratuitous comment. Carry on.
Yeah, this is Cassidy. Like, I think, in significantly unprofessional conduct that is abusive in the practice of law, a judge, when there's an egregious discovery sanction, that would fall under that, you don't need, or intentionally violating this separate standard that we don't want to, it's a lower standard, I think, than what we're within the first part.
This is Hunter. Hearing Dan's comments, I'm convinced that we can get rid of that because it potentially expands
Yeah.
appropriately what we're trying to do.
Right.
But the things that would violate that would already that we're actually going after would already be contained within this comment. So I'm in favor of getting rid of it.
Taking it out. Yes. And this is Sarah. I know Erica raised this, and it's appearing at the end currently. A lawyer should consult the civility guidelines, or I guess we're going to add, or other applicable. We'll have to tweak that language. Maybe this so consult the state bar civility guidelines or other applicable guidelines. Erica suggested, do we want to move that to the second sentence of this comment? Does it fit better there? I think it does fit better there, rather than after a lawyer does not violate by setting firm. But what do others feel?
You could also alternatively move the "a lawyer does not violate" into the first paragraph and leave "a lawyer should consult" as a standalone paragraph or sentence as an alternative.
I like it being standalone.
This is Raquel. I also like it being standalone at the end because it says, we've told you all this, but now go and look at
Right.
the guidance.
Right. Good point.
Yeah, this is Sarah. I agree with both comments that Cassie and Raquel made on that point. And I also, another reason why I like it being in a separate paragraph is I think it avoids confusion that we're saying the civility guidelines could constitute a violation.
Mhm.
A violation of civility guidelines could constitute a violation of professional conduct. I think it avoids that interpretation by having it removed from the section dealing with what conduct does violate the rule. It's that we're just citing to it for guidance. I think it makes it clearer.
Okay.
I think it'd be good.
How long is
So-
the report versus our 3 paragraphs?
We've had meetings where this is Justin, we've had meetings in the past where like literally the whole meeting was 1 paragraph. So welcome to COPRAC. This is how we roll.
And, yeah.
We're going to 6 o'clock tonight, right?
No. Please switch your place. Okay. So this is Sarah. Should we tweak the language now? The second paragraph, just to say that, and then we could take a vote maybe? Because I think everything else, so a lawyer should consult the state. Does anyone have handy?
I have it. Yeah,
Okay.
Bear with me for 1 second. I just gotta figure out which tab of my 1,000 I have open. It's the California, if they phrase it, attorney guidelines of civility and professionalism.
And I think based on, this is Sarah, based on Mimi's comment earlier and others, that we should add either and other applicable civility guidelines. Or
I think some of them are called codes.
other civility guidelines or codes, then maybe we should.
Can we just do authorities?
Authorities are.
Yeah, that works better, I think, for other applicable civility authorities. Before we take, this is Sarah, before we take a vote on this comment, does anyone want to propose any additional edits to clarify anything?
Yeah, quickly, I thought that on that last sentence, which is a lawyer should consult, I thought we were going to add for further guidance or something like that. I like that.
That is, yeah.
Yeah,
So consult for further guidance,
in the beginning.
For further guidance.
A lawyer should consult. And this is for Cal. It seems like we should have some reference with this California attorney guidelines, a year or something. I mean, because someone may pick up not the one that's current. And
Current,
I say that only because I Googled it and a number of them come up, and there's a number of a short version and a long version and a draft version, all in the same 2007.
this
Yeah,
is,
but we can't do that because if we put the specific year, then every time a new version comes out, we'd have to go back to
Change
court and
it.
revise the rule.
Okay.
can we just say current though to her point, which is now on the screen?
Current is
Okay.
fine, but being specific doesn't work because if it needs to be updated, it's kind of a
Okay.
pain.
It's not my
But yeah,
budget.
fine.
Okay, so this is Sarah, and I think we've made a lot of progress, and I propose we take a straw poll on,
It's not going, you gotta go.
okay, this is actually,
Biology won't.
we've been talking for a while, so why don't we take a short 5-minute break and then return for the straw poll? You're like a hard worker. Slave driver.
These meetings are so much easier in person. Oh my goodness.
Yeah.
This is so much easier.
Okay. Are we on? This is Sarah, and before the break, I had proposed that we take another vote on whether COPRAC agrees to the highlighted yellow language on the screen, which would be a proposed new comment, providing guidance on the meaning of subsection D of Rule 8.4D, what is meant by engaging conduct that is prejudicial to the administration of justice. I'm not going to read it. We just went over it, but it's highlighted in yellow on your screen. And if we could take a straw poll on whether members approve of this proposed language for the comment.
Okay, I'll take the tally. Sarah Benola,
Yes.
Ken Bacon,
Yes.
Raquel Brigham Brown,
Yes.
Elizabeth Bradley,
Yes.
Cassidy Chivers,
Yes.
Brandon Krieger,
Yes.
Joel Mark,
Yes.
Eleanor Mercado,
Yes.
Bill Munoz,
Yes.
Daniel O'Reilly,
Yes.
Kyla Rowe,
Yes.
and Hunter Starr.
Yes.
Unanimous.
Okay, and this is Sarah. And so now that I think we've had kind of a very engaging and very helpful discussion on the proposed amendments to the rules to address civility, what I suggest we do is we kind of reached agreement on the primary changes that we're recommending. And I propose that we revise the memo. The working group can work with State Bar staff in revising the memo to make clear the changes we're proposing and the reasons. Because right now, the memo does not reflect what the consensus we've reached. And it would just be kind of updating the memo to reflect the discussions we've had at today's meeting. So that's what I suggest we do to move this forward and get the memo and our proposed revisions to the Board of Trustees prior to their meeting, which is on, Erica, could you remind me again?
Our next meeting is December 2nd.
December 2nd. So,
A point of clarification, just in regards to updating the memo, would it be, I think what Justin described, to have this be COPRAC's recommendation, and then in the alternative standalone rule would be the second choice? And then a third choice being either no third choice or what was developed that was presented prior to this meeting and is already discussed in the COPRAC comments to this item.
Yeah, I mean, that's what's basically reflected in the into the discussion section of the memo, but I think we need to just update that consistent with our conversation today, which is that the committee feels it would be preferable. Here are the tweaks. We've done what you asked. It would be preferable from our perspective to deal with this within 8.4, and then here's this alternative to consider, which would be a standalone rule. And we say that in the discussion, but I think we need to refine it just to be more consistent with what our discussion was today.
yeah, I do agree. We need to refine it because I think the way I read it is more we were leaning towards a standalone rule previously. So yeah, I think it needs to be tweaked. But Erica, I think your point was mainly on, do we retain all these red line visions to rule 3.3 to 3.5 still? And is that what you're, like, do we?
Yeah, so I guess my question is, if the board were to reject this concept of essentially putting everything in the comment to 1.2 and the comment to 8.4, are we providing it in the alternative recommendation of both a standalone rule that encompasses what was proposed in 1.2, 3. Maybe 1.3, 3.3 through 3.5 and 8.4, or are we just and then additionally in the alternative, if a standalone rule is rejected, what is indicated in the current red line, or are we proposing just standalone rule to be drafted with these concepts?
Yeah, I understand I'm trying to. So I think the first two options are clear. That a third option, just to add some, just for my own, I'm a little unclear. I think the third option, aside from keeping what's in here as the last alternative, which is not our recommended alternative, the other thing I guess we could propose is if option 1 or 2 are not adopted, we don't recommend any changes, period. That could be a because it seems like we have a lot of problems with the other, rules 3.3 to 3.5, for instance.
So we skip over.
So I don't, is that something else we should consider either? So the first two options, which we seem to be in agreement with, but it's a third option that I'm a little hesitant on. Do we want to just say, which would mean we take out a lot of the stuff that's in the memo, the redlined edits.
Right.
But if you don't agree with the proposed 8.4D addition or the standalone rule, then we don't propose any changes be made.
That would be my recommendation.
No changes in this bill, no changes or no amendments to.
No amendments.
No amendments, right? Is that's, okay.
Is that too far from what they asked us to do? I like the available outcomes we're offering, or are we putting ourselves in a position where they're going to do what they want to do without even our red line?
Yeah,
I'm not sure.
That's a good point.
Sorry, this is Brandon.
I mean, this is Justin. I see it more of like it's like a spectrum. It's like three soft options that they can pick and choose as they desire, given what our directive was, which was mainly to provide feedback on what the revisions were. So we've done that, and then we've also said, look, please consider these other options as well, and pick and choose based on what your purpose is. So I don't think that we have to say, it's this way or that way or nothing at all. I think we can say, this is a menu to choose from, do as you see fit based on your purpose, rather than boxing ourselves into a corner, I think, and making it, if they don't agree with something we've suggested, making us seem somehow like we overstepped or we're completely rejected. I don't think we need to go there. I think it could be more of an entree for them to select.
Yeah, this is Sarah, and I understand that approach, and I tend to agree. And especially because we've already put all the work into proposing, tweaking certain language. And so in the event, the board doesn't agree with our proposal, at least they'll have some alternatives to consider. And I think we could be a little clearer in the memo up front about what we really are recommending and why, to try to, strongly advocate for our number one option, but while presenting the two alternatives.
Yeah, like you do with a client, right? I really think you should do this, but you have the right. Exactly.
This is Raquel. Can you, Sarah, say what option 1 and 2 is?
Yes, this is Sarah. So option 1 would be a proposed comment to rule 1.2, which we took the straw poll on and agreed to, and that's giving an example about the lawyer's authorization to, for example, agree to reasonable requests of opposing counsel. And option 1 also includes a proposed comment to rule 8.4 to clarify the meaning of subsection D, which refers to conduct that is prejudicial to the administration of justice. And so the proposed comment would provide guidance on that. And that's the yellow highlighted language that's still on the screen right now that we just voted on. So that would be COPREC's first recommendation, and what we think would be the best outcome to address civility.
And everything else would be gone.
And yes, so yeah, to clarify, all of the other amendments to the rules 3.3 to 3.5 and the definition of incivility in 1.0.1, we had proposed to not consider those amendments that the Civility Task Force proposed. So then option 2 would be to not incorporate any of the proposed amendments that the Civility Task Force made to the various rules, starting with 1.0.1 to 8.4, and instead draft a standalone rule that addresses attorney civility, similar to the current rule 8.4.1 that addresses prohibited discrimination in the practice of law. So that would be option 2. And then option 3 would be, and I don't know if you were asking option 3, Raquel, but option 3 basically be tweaking the Civility Task Force's proposed amendments to all of the rules that we've gone over at today's meeting, starting at 1.0.1, ending in Rule 8.4D. We would tweak the language of each of the proposed amendments. And that's presented currently in the memo with the green highlighting and the strike throughs. So hopefully, I hope that was clear.
So what is our real recommendation, the second option?
The first.
Or is it the first?
The first is our real recommendation, what everyone appears to be most in favor of.
So I'm less likely to give all these options, because I think then we're not giving them we're giving them what they need, not what they want. In other words, they ask for X, but our professional advice is this is what should be done. And so I think when you start giving people options, it negates our professional advice. I mean, they can choose those options anyway, right? We don't have to say these are the options. They can say, we like what they did and choose that. So I'm less in favor of giving people a lot of options, that especially ones we really are not in favor of. Because they can always choose it themselves.
So Raquel, so this is Sarah. So are you suggesting you would prefer to just present option one? Is that what you're saying?
Or two, but it sounds like the third one is like we would be saying, that's a bad idea. No matter who came up with it, like, that's a bad idea. So why would we put that on the table for their consideration? Even though they had a committee and they came up with it and all of that, like,
Well,
we
that
shouldn't say we think that's okay, but with the realization that they may still choose that. And that's okay, because that's.
I mean, the option 3, as I understand though, because is they came up with their proposed rules.
Right.
And we came up with revisions to those because they're not good. So if we take option 3 out and they reject option 1 and 2, then they'll have their rules without our proposed changes, which make them better. If I'm
Yeah.
following all this.
This is Hunter. I think the idea of, I absolutely agree. The more options you give, the more it seems like we're fine with any of them. I think that's just a matter of phrasing in the memo.
Right.
This is what we think you should do.
Strongly.
If you're not going to follow that advice, and I think this committee would have some weight when it comes to rules of professional conduct. If we don't give them the others, there's always the chance that if they disregard the advice, then they're going to go with something that we would also have a problem with. So it really is a matter of letting them know, this is what we think you should do. Here are our 2 improved options. And I think we've got to give those to them.
Yeah, I mean, I guess the question is this is Cassidy. The question is option 3 just such bad advice, such a bad option that regardless of whether or not they're, revised, it's just like you would never make that recommendation to a client. Like, I like the idea of framing it as how you would advise a client. You would never give just absolutely bad advice to a client, as in the form of an option. So, but that said, I think we should weigh in favor of adding the third option with the strong recommendation against choosing it, without and not taking it out altogether.
And I just have one further point of clarification. This is Sarah, and I am in favor of presenting all options, and I understand the points that Raquel made and Cassie that you just made about, if we really don't feel like option 3 is a very good option, why should we be proposing it at all? But I do think, we presented this from the Civility Task Force. They spent extensive time developing these proposed amendments. They had a lot of, attorneys and judges involved in the process of proposing these amendments. And I think kind of respecting that process that happened, it makes sense to include an option that give serious consideration and suggest revisions to those proposed revisions. Because I mean, we're one committee of attorneys who focus. Some of us focus on ethics, some of us focus on other fields. But I just think, out of respect for the process that's happened before we got them, I think it makes sense to present all three alternatives.
Very diplomatic. That's good. No, I think that's a right way to think about it.
I'm that's not how I generally work. I'm from the East Coast. I'm
We think
usually
it's a
blunt,
bad
but
idea.
I don't want to be
You took a lot of time on
discourteous,
that.
but like, if you insist on doing this, here's what we would suggest you change to make it something that we think is bad, not quite as bad.
Well, by showing all that work, it shows we've taken what they did very seriously.
Yeah, that's true.
Like we're not being glib about this at all.
Exactly.
It's a committed substantial time. and effort.
Right. And you know what? We're not but we shouldn't be so, we should have some humility too. There were judges and lawyers. They had reasons for what they came up with that maybe we're not thinking of. So I think we should,
True.
kind of step back and.
Well, this is Joel. I mean, they asked for our opinion, and I think option 1 and option 2, give them our opinion. And if they want to go to option 3, they can find that themselves. And they do. So I would just go with option 1 and 2, and I wouldn't rank them because I think a further discussion among that group between the options or the things that we think are important would only improve things.
So
I can go either way.
this is Erica. I just want to say what COPRAC was tasked with by the board. I think that may help us again to get back to where we started. And so what it says is COPRAC will submit to the board a public comment proposal for any amendments that COPRAC believes would be enforceable and consistent with the purpose and function of the rules as disciplinary standards, as opposed to aspirational guidelines. So
Did we accidentally do exactly that?
I think we did.
Yeah, so
Yeah,
number 3, there's
Number
no
3 doesn't.
number 3, it doesn't meet that criteria.
But to
No.
show your work, let's say, it may be of benefit to say, we were tasked with the following. We started with the CCTF recommendations, attempted edits to those, and do not think that as edited, these meet that standard that the board asked us to look at. In the alternative, we came up with this. Our second alternative is a standalone rule.
That's a good way of putting it because so you present our revisions this is what we tried to do. So show your work, right? And then it didn't work. And so here's what we suggest. Because then you still see that we took it seriously. It shows options, it's not an option, but if they really, really, really want to go with the rules, then they at least have our revisions to it, right?
I think it's a more respectful, was it a more respectful approach to that? Look, we tried to do what you did in the parameters you gave us. And our conclusion is you can't do that. It doesn't work, as opposed to no, this is terrible.
Right.
But if you insist, then here's what you can do.
Much more scientific.
That is what happened.
Yes, exactly.
It's exactly what happened.
Yeah.
No, and this is Sarah, and I agree, because it took us to this meeting to really come up with a more concrete proposal. And we've discussed that several COPRAC meetings in addition to 2 or 3 working group meetings. And I think it took us a while to get to this point. We did take everything seriously. And I think some of the concerns we raised today, we didn't even identify previously, because there are a lot of different issues that, we were concerned about. But I think I agree overall with what you're saying based on the process.
Yeah, I like that, Erica.
I think Justin actually said it about 15 minutes ago. I think I just restated it.
This is COPRAC.
Wait till everyone says.
All right.
So the net is the same, there's 2 options.
Yeah. Yeah.
I like it.
Well,
Way in, frame it.
Yeah.
But if they're gonna completely ignore our options, we've given them
Yeah.
some pointers as well.
And
Embedded in our
yeah.
discussion
Just-
part.
This is Justin, just to close us out. I mean, this is kind of par for the course. When we get requests for private input on proposed changes to the rules, inevitably, we have our own perspective as COPRAC. And so as a matter of diplomacy and mindful of those who looked at this carefully and came up with different wording than we would, it is not uncommon that we follow this type of format,
Right, so
for
what,
better or worse.
Yeah.
Because, we are working functionality wise, like as a team, with different, committees in the state bar. And so we end up with this kind of memo, this kind of structure where we are respectful of the process that came before us, provide our input on that, and then also our own flavor for how we would recommend going about it if they choose not to go down the path that we would and stick with their own formulation. So how this is played out is how it often plays out, and frankly, how I would expect it to in the future.
so what is the track record? Do they typically listen
lot of
to
things-
it?
That's a great question. I haven't looked back at what they've done with what Ms. Wilson talked about with 1.4.
Right.
I haven't seen that's the most recent example where we gave feedback. I'm not sure how that played out. That's a good question.
Yeah, maybe we should have some data.
Yeah. You think we're ready to vote?
Yes, I am. So, okay. This is Sarah, and I'm going to try to summarize concisely what I think is on the table we're voting for, which is basically State Bar staff and the working group will revise the memo to recommend primarily option 1, which we've been discussing, which is a proposed comment to Rule 1.2 and a proposed comment to Rule 8.4D to address incivility. And we will present as an alternative option 2, which is a standalone civility rule. So the memo will be tweaked to make that very clear upfront, what our primary recommendation is and what our alternative recommendation is. However, we were also discussing the background section, I think, that, we seriously considered the other proposed amendments to the other rules. And we do not believe, Erica put this in better words, but we don't believe they would be consistent with our tasks, even with those amendments, because they wouldn't be, we don't believe they'd be enforceable as disciplinary standards, basically. However, we are presenting them in the event the board disagrees with options 1 and 2, and to provide background for the process that COPRAC went through. So I think that's the way we would present our proposals. And we can tweak that a little bit, but I propose that we work on that as part of the working group along with State Bar staff, so we can get something to the board in advance of its December meeting, which probably has to get on their
Apologies.
agenda.
It's a November 18th meeting for the board. I thought you were asking if the COPRAC meeting was.
Okay, so it's November
Apologies.
18th.
November 18th.
So when do the agenda materials need to get to them then?
So soon, yes. So the agenda materials, there's internal deadlines, but they are ideally given to the Board of Trustees with Beckley Keene requirements 10 days prior to the meeting.
Okay, so early November. I don't have the exact date, but okay. So given that limited time and that we won't have another COPRAC meeting, what I'm saying that we should vote on is to authorize this working group and the State Bar staff to revise the memo consistent with our discussion at this meeting.
On motion? I'll second it if it is.
Yes, that's a motion.
Oh, that's not a straw poll, or whatever.
Yeah, I guess we've been taking straw polls because I don't,
This would need a motion.
this would be a normal formal. Okay, so that, okay,
Second it.
okay,
I will take the vote.
Elizabeth?
Sarah Panola,
yes.
Ken Bacon,
Yes.
Raquel Brigham Brown,
Yes.
Elizabeth Bradley,
Yes.
Cassidy Chippers,
Yes.
Brandon Krieger,
Yes.
Joel Mark,
Yeah,
Eleanor Mercado,
Yes.
Bill Munoz,
Yes.
Daniel O'Reilly,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Yes.
So that's motion passes.
Sarah, I mean, this is where Sarah, in your description, you didn't say you'll be saying the why of the recommendations, but that is included, correct?
Correct. Yes. And now that we've spent so much time on the civility amendments, I'm trying to pull up my agenda. I had a lot of different stuff open, so just give me 1 second to catch up here. So next on our agenda is the ethics of the in-house counsel draft opinion. And since I've been speaking for a while, I'm tired. And since Cassidy is the lead drafter on that opinion, I'm going to let Cassidy take the lead on discussing the revisions to that opinion. And maybe you want to provide some background for the new members before diving into the revisions.
Yeah, so gosh, all the way back from the beginning. So this is an opinion that has been in the works for the past year in various forms. It started out as more of a broad, general, general guidance for in-house lawyers on various ethics issues, because there really aren't a whole lot of ethics opinions out there that give guidance to in-house lawyers. And then we narrowed it down to specific conflicts issues, and the conflicts issues that we chose that that I've seen is when in-house lawyer, it's drafted as a hypothetical basically, but the hypothetical is in-house lawyer moves from one company to another company that are in a similar space. And so the question is former client conflicts 1.9, 1.10. And then the question of the lawyer's compensation, and specifically whether or not the lawyer, the employer's offer of stock options through a general stock incentive plan creates a conflict or disclosure or conflict requirements under Rule 1.8.1 and 1.7. And then the final piece of the opinion is when there's the fact pattern is that the company is being sold and the lawyer actually owns stock through the stock options, and whether or not that particular circumstance creates a 1.7 conflict, and whether or not the lawyer can actually advise the individual shareholders of the company, as well as the company itself. So that presents joint client conflict issues. And so it's a myriad of conflict issues that a lawyer may go through in kind of the course of their employment. So where the opinion is currently, it's gone through several drafts. The draft that we went over the last time we went over, I can't even remember if we went over it in the last meeting. It was incomplete. It's come more complete now. So I don't think it's ready to be reviewed in sort of word by word. And I kind of want to go over more high level concepts because after we had a subcommittee meeting and I went through it and I just thought this needs way more revisions. So one of the issues, apparently I don't know, have you guys read it? I mean, okay.
Who's on the working committee?
It's Sarah and Kyla, right?
I can preface because the first part that comes up is the first question, which is the more general question, and that's kind of the part that's the most work in progress, I'd say. So
no, So I think the whole thing is still a work in progress. So no, like, I'm not criticizing, there's no criticism at all. It's just, but, sorry, I didn't mean to interrupt you, Kyla. I just want to make that clear that, no, you.
Yeah. So I agree that I think people shouldn't focus on the wording quite yet, because that's certainly still a work in progress. And just for that part, I think we've decided that the conclusions that we come to and kind of the analysis is the same. And it seemed like the committee agreed with that in terms of just our discussion of just being in-house counsel at a company does not make the matter substantially similar to being in-house counsel at a similar company or a competitor company, for all of the reasons like it having issues with career mobility and stuff like that. But it's going to be reworded and fleshed out a lot more with California case law about what is substantially related in terms of matters, and what is, and the playbook, and all the confidentiality issues. So I don't think we necessarily need committee discussion on that part, but obviously happy to hear anything, that any comments that people have about what language was struck or what language was added, but don't be too focused on the language itself.
One more comment and then I'll pause there. I think that we do need to flesh out more Rule 1.9A. I mean, what I'm thinking is, I think we should hew closer to the ABA opinion that addresses this. I mean, there is an opinion that the ABA issued. It's 415/97. That actually talks about this issue. So we definitely have some more concrete guidance on the former client conflict issues. And so I like the way that opinion went through more methodically the four elements of Rule 1.9A, which is there a personal representation by the lawyer of the former client? Is it the same or substantially related matter, which we do have in there? And then is there material adversity between the former and current client? So I think we can flesh that out a little bit more, and then separately address 1.9B, which I think we struck because it was redundant, because it had to do with whether or not the lawyer has acquired confidential information. And I think we can, but we still need to address that separately. And then finally, I think we do need to address screening, because the ABA opinion addresses that in its footnotes 18 and 19. And that's where I think last time Dina mentioned that, the screening issue could be addressed, and that it should be something that the general counsel of the new company should go out to, that's where you consult with outside counsel on, whether or not this is a screening situation, I think our fact pattern kind of presents a close call, really. So it just needs to be fleshed out a little bit more. So I'll pause there if anybody has any comments on the first part of the opinion. No.
Justin, just to piggyback on what you were saying about the screening question and that being looked at sort of from the lens of the new company.
Yeah.
I kind of had the same reaction in the discussion around red line, line 182, where it's talking about how the lawyer should evaluate the extent and nature of the confidential information learned. How I've seen this play out is that the new company doesn't want to have its whole in-house department disqualified.
Right.
And so they want to know, well, does this lawyer that they're bringing on have confidential information, but they don't want to know what the confidential information is. And they can't gain access to it. Otherwise, they might potentially be disqualified if they hire this person on. And so that creates a real challenge for the company. And so what that got me thinking about is if we can or should evaluate not just what the lawyer himself or herself is considering, but how on earth does the new company who has these restrictions as to what it can or wants to learn is supposed to deal with potential conflict issues and work those out without it ultimately conflicting itself if it hires this lawyer who is conflicted. And that seems to be the tension that I've seen in my practice. And that's a real difficult issue.
Right, so, I mean, there's a certain level of risk that they would have to take on, but do you think there's a two-step process there? I mean, how would you, how do you make that decision? I know, I've had conflict situations where you can't figure out if there's a conflict because you can't learn the information, the confidential information, and so you have to just decline the representation. But here it's like you can't hire the person.
Right. Well, sort of at a minimum, I think of like in my like lateral questionnaires, like how much information should you get in order to evaluate whether there's a conflict if you take this person on, and then how far is too far in terms of what you ask for in some questionnaire like that might ultimately get you conflicted. And I think of the Schlumberger case and those concerns, right? That if you ultimately bring that person on and you can't screen them or you fail to screen them, the serious consequences associated with that. And so I thought that was sort of a maybe a challenging angle for us to tackle here, but at least from my own experience, that's the angle that I've seen. Is what are these companies, what should they do to address the conflict outside of just screening, even before you get to screening, ensuring that this is somebody that could be taken on without ultimately gaining information that they shouldn't, to the extent it exists.
Okay.
So I guess what I'm saying maybe to distill that is we're looking at what the lawyer should do here, but I'm also wondering if we should add the angle of what the law firm should be doing, even before it gets to the possibility of a screen. That isn't deciding if, how, when this lawyer could be brought on without getting entangled in a conflict.
Justin, this is Brandon. I think that is such a fulsome and interesting issue. I wonder if it's worthy of more independent inquiry.
Should we talk about it at 4:00 when we discuss the topics?
Right. So, I had a thought about screening, because I think an analysis of screening would be interesting here and useful. But if it's a 3-person legal department, can you do a screen?
Right.
Should we change the facts? So
yeah,
that
and
you
that's
have it? Yeah.
Yeah. So I'm sorry, because I'm getting, because part of me, as I'm writing it, I'm going, oh, we got to change the facts here. Like, do we really want a small company?
Right.
Because, and that leads to other issues. But I think these opinions are more helpful for the startup, the lawyer, well, again, so that's why I'm so conflicted about this opinion, because there are it just keeps, spawning different issues, and I need to wrangle it. But maybe not a huge company, and maybe not a startup, but maybe a legal department that has 10 lawyers, where there still are, there's still an ability to, screen a lawyer from, from a particular, the tech side of things versus like the business side of things or something. So maybe we should change the facts a bit.
This is Dan. I've dealt with some of these similar ones in different size companies, and one, I think, the closest we've come to solving the problem that Justin described is basically, I think of it like the analogy of in a deposition, questions related to privilege without getting to what the privileged information is. And it's really difficult to say what that is in every instance, but in a large company, not every in-house lawyer has access to everything. So without telling me what it is, did you work on X? Do you know anything about X? And maybe that's even too far, but it depends on the circumstances. If they say, no, I wasn't even in the same building, it's actually like, oh, they're in different buildings?
Right.
So it's very treacherous, like as you described, but there are, segmented things inside larger, small companies, and in-house lawyers, partly for this reason, don't know everything about everything. If you can ask the questions like you would in a deposition, sometimes it will be like, I don't know anything about Google Drive or whatever, you know.
Yeah, that's a good point. Yeah, I mean, because so maybe are we giving guidance to like the new company on maybe you should be segmenting these things so that you don't have,
Because here's the reality. It's the new company that's going to be really, you know what,
Screwed, right.
if there ends up being a conflict, the lawyer, at least in my experience, tries to put the onus on the company to figure out if there's a problem and has sometimes an incentive not to divulge maybe as much as the company would like to have divulged so that it can fairly vet whether it might ultimately face a disqualification motion.
Right.
So a lot of that conflict analysis and anxiety comes up on the company side as opposed to the lateral lawyer side. So
right. And of course, they're looking for a lawyer who has the experience and
Right.
background and knowledge.
If you don't know anything about the Rockets, why are we hiring?
Right, exactly.
You know?
So, okay, so I mean, again, there's some real world analysis and facts that need to be, infused here that it's very helpful that I need to kind of figure out. Okay. Oh, the other question or issue that we talked about on this part was the question about NDAs. Like what if the old company made lawyers sign an NDA and how does that impact? But I think doesn't that just mean that the lawyer has a duty of confidentiality because the former client said, don't divulge this. This is confidential. Don't divulge this. So it just falls under, 606AE. And then it falls under 1.9C. You can't disclose or use your client's confidential information. So I couldn't think anything beyond that, how, the only thing I can think of is if it's an NDA and a non-compete, which is a problem. And, they can't, and that there's an ABA opinion on that. So I thought I can put something very concise and not a big part of it into a footnote about the NDAs and non-competes and how that fits in here. So that was kind of my own.
I think that would be helpful too, because I think for candidates and for companies, they're dealing with NDAs, and they want to be able to say, well, I'm not going to tell you the information about how the rocket goes, but I know how to build a rocket because I worked there for 5 years.
Well,
not their rockets, but rockets.
Yeah, I mean, so that leads me to my thought of, okay, well, what's the difference between, can an NDA cover your work product? And I don't know the answer to
What's
that
in
question.
your brain, your expertise?
Right.
I don't think so.
No.
That's my opinion.
Yeah, no, because there's actually employment cases that have to do with, your know-how that you take to the next company. And, there's my dad was actually sued for this and he won because, and it's a long story, but it was his know-how and it wasn't the company's, but anyway.
Also, we're talking about lawyers, so they're not going to really have a lot of technology in their heads. Typically, the NDA is going to be related to processes.
Right, it's easily more set, like your work product is like your legal work product and they don't really care.
Right.
They want to protect their tech or proprietary information.
Right. So I think it's easier because they're going to be segmented already because they're in the in-house lawyer department.
Right.
And
Right.
So,
right.
They don't necessarily retain or even get exposed to the deepest, darkest secrets.
Okay.
Some do, but hopefully not everybody.
Well, yeah.
Yeah.
Right. I mean, if you're a startup and you're like, you're the general counsel, but really you're in the business.
Yeah, that's right.
And
But you can draw those distinctions.
yeah. Well, not yes.
Yeah, and that reminds me of that Nevada case that you directed me to, Cassidy, that was about the gambling, like card shuffling patent, where it was an in-house lawyer, but they had I think it just came down to confidential information as opposed to, but the analysis was a little bit like the playbook, because they just ended up finding out that this lawyer that moved to another company that was prosecuting the patent infringement of this shuffling machine had just been fully involved in every step of, how to defend this patent, and knew all of the nuances of it, and knew how the company constructs the claims about patents, and knew exactly like where they would settle and where they wouldn't. And it just became like so unfair. So that, I think that's a pretty rare situation. I think it's more common where an in-house lawyer is more general and more of a business side thing. But I think it does come down to a lot of what information did you gain, and is it fair or unfair to have that information in the new company?
Yeah, and the ABA opinion, it has good guidance on that. And I know we have some of that in there, but I think we can rely on a little bit more to make those distinctions. Yeah. Okay. So the second part is whether or not Rule 1.8.1 applies to, so originally the idea is, lawyer goes to new company, and new company says, okay, here's your employment agreement, here's your stock option, stock option agreement. This is what we give to everybody, or all key employees. And that, we came to the conclusion that 1.8.1 shouldn't apply to that scenario, because it's, the bargaining power, the purpose behind 1.8.1 doesn't fit in that scenario, because the bargaining power between employer and employee is really what fits there, which is that the employer has way more leverage in that scenario than when, a lawyer takes stock in a client, and, it's basically, you're trying to prevent them from taking advantage of the client. And then it kind of morphed into, you think about it further, well, what about like performance reviews, where you have, maybe they are increasing the percentage of stock, or, and it's still kind of like the basic, what every employee goes through. It's not like a specific transaction that, that the lawyer there's a risk that the lawyer is taking advantage of the client. And that was the Chisholm case out of Washington. And so the Chisholm case wasn't a stock option. It was a bonus that the lawyer negotiated during his tenure as general counsel. And the case, I can't remember exactly procedurally what happened, but, the court said that Chisholm is out of Washington. The Washington 1.8 doesn't apply because of that, difference in bargaining power. It's not, the policy behind 1.8 doesn't apply. And I thought that the language there from the court made sense. But it also said, and this is where, after we had our meeting, it also said that Rule 1.5 doesn't apply, which is the, that the fee, the fairness of fees, unconscionability of fees doesn't apply to wages or comp, employee comp, basically, which is what this lawyer was. And then, so we're at the end of the day, and I'm trying to like explain this so it makes sense. So the comment to 1.8 in Washington and in California is that 1.8.1 doesn't apply to standard fee agreements, right? You don't have to give the client the 1.8.1 disclosures and consent when you're entering into a contract with the client for representation. And that applies that I think the Chisholm court and I think the ABA task force that is cited in here applied that same rationale here, is that when you have an employment agreement a company is offering an employment agreement or that, a typical employment agreement that has stock options, it's similar to a standard fee agreement. Does that make sense?
Yeah, and just to clarify a little bit, this is Sarah. I think the rationale of both the ABA and the Chisholm case, which is what state was that from?
Washington.
With the Washington case, is just that the lawyer's not getting an unfair advantage.
Right.
Doesn't have a bargaining advantage. And one of the comments that the Washington court relied upon in the Washington rule is similar to one of the comments to California's rule 1.8.1, which is comment 6, which says this rule does not apply where a lawyer and client each make an investment on terms offered by a third person to the general public for a significant portion, or to standard commercial transactions for products or services that a lawyer acquires from the client on the same terms. The client generally markets them to other, where the lawyer has no advantage in dealing with the client. I know this isn't addressing exactly the same thing as what the comment is saying, but it's similar to the meaning of that comment, where it's kind of a standard agreement that's offered to many employees. You don't have an unfair advantage in dealing with the client when you're dealing with when you're dealing
It's an
with your
arm's length
employment
negotiation.
contract. Yeah,
Yeah.
So that's the reasoning, and I think the Washington court applied that based on a very similar comment.
Right. So the whole idea that fee agreement is an arm's length negotiation and a stock option to an employee is an arm's length negotiation, it doesn't connote an unfair advantage. But, when you're talking about a fee agreement, Rule 1.5 still applies. The fees have to be fair. And so then I went back and read a law review article on this issue, and it kind of made sense to me. And this is a quote. It says, the comment identifies a clear conceptual fork in the road to a consistent and coherent construction of Rule 1.5 and Rule 1.8a. Either in-house pay, including salaries, is a fee subject to the reasonableness requirement of Rule 1.5a, or it is not, in which case it constitutes a business transaction subject to the heightened reasonableness requirement of Rule 1.8a. So if we're not going to say that 1.8.1 applies, then I think we may have to say that Rule 1.5 does apply, to that arm's length. You still have to have fairness in your fee. And Chisholm rejected that, not because it was an unfair, the unfair advantage issue. It was because a wages isn't a fee. A bonus isn't a fee that, doesn't fall under that kind of rubric. So, and this law review article criticized Chisholm directly. So my question is what do you guys think about that? I mean, I feel like, is there anything that then governs that arrangement? Is there any ethical rule that should govern that arrangement? And
Sorry, this is Brandon. So I need to read Chisholm, but when I was looking at the excerpts from Chisholm and sort of how you've presented it in the piece too, is that it's focusing on this bargaining power
Right.
dynamic, which is to me just one aspect of 1.8. Like when you look at Fair versus Bakhtiari or our 16004 probate code, it's about also sophistication and information asymmetry. And this may be injecting much more trouble into the opinion. But one thing to think about is where I've seen this come up is where in small companies, in-house counsel is consulted about these agreements that are going to apply to the whole company, including him or her.
Right.
And to me, I always argue 1.8 all over the place because it's subtly different, right?
Yeah, and that's the kind of my next thought too, is that where do you draw the line? So, I mean, there is the Fair versus chart. I look at it and I don't know how to pronounce it. Where the lawyer goes into business with the client, and that's not what we're talking about here. And I think that that's why I was struggling with how do you articulate that line, the difference between lawyer goes to even a small company, but the company has an established stock incentive plan. It's got stock options. It's something that's offered to all the employees. There's no unfair bargaining power versus lawyer and a bunch of his buddies decide to form a business together. And, lawyer says, hey, I'm going to take 15%, and they're like, yeah, that's a good idea. And there's no independent counsel advice, you
Right.
know, and there's certainly a lack of sophistication, and there's certainly a vulnerability. So I think that, you know, I don't think we can just cut to the chase and say 1.8 doesn't apply. I think and people help me articulate that line, because I think this is an important opinion. But I think we have to be I have to be very careful about where that line is drawn, because you're right.
I think this is a super important opinion and treading into some unsettled areas, because anytime I've litigated this, it's been a battle between the rules of professional conduct and labor code.
Right, we talked about this
And
last
it's
time,
just-
yeah.
And I don't know how it resolves, and nobody does, and we negotiate something.
It's also, this is, it's also true that these in-house lawyers typically don't think about either of those. rules.
No, well, and that's the problem. I mean, right, and that's the problem, is that so I came across a law review article that was like, in-house lawyers should never have stock options. And it's like, that's never gonna happen.
Right.
So, like, we need to come up with guidance, and where the rules intersect with, their business, because they don't think about it.
But I think it is the line that Brandon described, where it's like the purpose of 1.8 is really more about the power.
Yeah.
And sophistication and expertise. And once that starts to get crossed, then it applies.
But how does the lawyer, like, I mean, in my mind, it's, okay, going into business with client versus, being offered an employment contract from an established company. Those are two different
I think
things.
it's Brandon, the initial employment contract totally seems arm's length to me. But over time, if there's like a new stock option plan and the company says, hey, we need to run this past our legal department, then we're in some mush, right?
But
One of the
who's the
questions is,
legal
how much
department?
does the general counsel usually get? Right? And then the general counsel says, most of it.
Right.
Yeah, we were
No, I
just
know, but
discussing
then
that.
you always need a lawyer. So should it be that they always go outside to get advice? See, okay.
Well, this is where Cal, I think the other person in this situation that gets consulted is HR.
Yep.
It's the same thing, and in that profession, they're not having this conversation.
In a small
Like
company.
that-
So that really, yeah, it's really about the size of the company.
That's
Yeah.
dealing with-
General counsel.
With employment,
You're
so,
right.
yeah, so I think you may be putting a more onerous standard on an attorney in this particular situation that,
Yeah.
because of it's not because they're
Well,
doing something, they have an unfair advantage. It's part of their responsibility.
It seems like almost the smaller or less sophisticated the company, the more we're going to require of the attorney. And I don't know if are we comfortable saying something like that and explaining our basis? For
I think we have to.
Because if you go to work for IBM, nobody's going to think that one attorney at IBM is like pulling all the strings. But a little teeny company, maybe they don't have formal HR, maybe they don't have this or that. It's different, right?
Yeah.
This
This is Eleanor. I was just going to say, I think it's also hard to just determine when when the power the attorney has is coming from their business contribution, because they're acting with dual hats many times. So drawing distinctions there, what power are they using to exert this influence? Is it really in their service, in providing legal services or not? This seems like a very complex one to me.
This is Elizabeth. I was going to say it's not necessarily the size, although that can often be a big factor, but you could have someone extremely sophisticated and it still be small. Elon Musk
Right.
starts a spin-off company and says to his friend, hey, come on, let's do this. So I don't, kind of like the factors and the unconscionability analysis,
Right.
and you look at sophistication and the history and that kind of thing. It seems like it's hard to take a hard line either way, but if hypotheticals can help illustrate.
Yeah. I do think, I do think 1.5, getting back to that, provides sort of a backstop to that, because at least when if the lawyer can't really determine who has the power in this scenario, then you still have, you're still governed by 1.5, that, the vulnerability. I mean, it's not just informed consent from the client, but it's all the other factors of I can't think of them off the top of my, do you have them?
I have a broader reaching,
yeah, the
fail to
overreaching.
disclose material facts. I mean, that doesn't really apply here, but there are.
A lot of them don't apply, but yeah.
But, yes, but the one point this is Sarah, that I also want to make that I think is helpful, and we're talking about where to draw the line, and I think the draft that's been presented, it does already have that Cassidy prepared. It does draw that distinction, which I think is very helpful, between where the attorney is involved in informing the company. And Cassidy already made this point, but it is in the current draft. That's kind of where the line has been drawn. It hasn't been drawn further, but where the lawyer is involved informing the company, it's not our opinion that Rule 1.8.1 would not apply to that situation.
Right.
We're talking about more routine employment law agreements, and that's what we're trying to articulate in the draft. And the other, just in response to your question, Cassie, that you raised earlier, I disagree with Chisholm in terms of that, saying that Rule 1.5 would not apply. And I think others have said this, but I do believe that Rule 1.5 would apply. There's not really an exception,
right?
Based on either the purpose or even within the comments, that we could argue for an in-house lawyer, it doesn't apply. I think.
Could I ask just sort of maybe a very basic or uninformed question? So I've heard some people, this is Brandon, talk about in-house counsel relationships as somehow different from a normal attorney-client relationship. There are a lot of people that think an in-house counsel cannot be sued for malpractice. I don't know what the authorities say, but is it in any ways like sui generis, its own, or do all the regular RPC apply fully?
Oh yeah. Well, but that's what, so the intro is, yes, the RPCs apply fully, and that's, a legal department is a law firm for purposes of 1.13 applies to.
So the company is just a client then, right?
Yes, yeah. So we have to kind of work within those.
You don't see it that way.
But how does the labor code, so just to, in cases where
That's why they go.
an attorney takes a piece of a company and we have an argument about the attorney didn't satisfy 1.8, the attorneys always argue, well, then labor code applies and I get, a wage for all this time I put. And it's like, how does it?
I don't know.
See, and I just don't know how that works either. And I don't know that we have to get into it, but it might inform what we're doing.
Yes, that would be helpful.
Yeah.
I mean, I'm like, oh my God, do I have to go read the labor?
Yeah,
code?
and I'm not aware of answers on that.
Don't make me do that.
I'm not trying to make it worse.
No. I mean, it's important. Right. So it's just a can of worms. But I come back to, this is really important because I have, it's amazing to me, how much. Well, I think they want to have a comfort level when they do go to IBM and they are presented with an employment contract and they are given stock options and they know about 1.8.1 and they're thinking like, well, doesn't this on its face it applies, But so it would be nice to say no, and here's why, but here's where it does apply,
Yeah, I mean, I maybe I'm looking at it naively myself, but what's the downside of it applying? If you're getting an interview, you're going to go to work for this company,
and you come in
and they want to, they're going to issue these stock options, and your obligations, lawyers, they have to be fair and reasonable. Explain, if they're going to give it to you, and they want it's
because it seems so facile, and it also, I think that it hasn't happened up until now. So you're going to go back and say all of these transactions, all of these deals that have happened, from time in memoriam, where in-house counsel have to be, they're all suspect now. I mean,
There's a single person on earth who has done that.
No.
You know what I mean? Like,
well, it would be really weird to interview for a job and then they hand you an offer and
you're like, here's my
and you say, you have the right to independent counsel. Like, it's strange.
just go to the in-house department,
right?
Somebody else will have the stock option.
And this is there. That's why I think that, at least that's the 1.8.1, I think there is a way to regionally interpret the rule along with the comment particularly given the comment that I referenced earlier to say that it doesn't apply.
Well, to the
that type of
initial,
situation.
to the initial,
Right, and so that,
but
I
it's
know,
harder as you go in, right?
yeah, and so that is, and I,
That
Well,
that
doesn't
I
that just
haven't,
become
that
the
I'm not sure
personal
about.
interest as you move forward?
Well, maybe not, but that's.
well, then it's a 1.7,
Yeah, it's a
so
1.8.1
1.7.
moving
complex.
forward, it's the,
No, and that's what I was gonna say, is that it's not really a 1.8.1, well, it's a modification of a fee agreement, so it would be 1.8.1. So yeah, that's where I kind of, and then the question is, well, that's not part of our facts, really, is, there's no like,
Yeah.
we don't have to address it, but it is an interesting question, so what happens if you, when you, well, when you have a stock incentive plan or stock options, it's set, right, vests over a period of time. You don't normally, on performance review, do you normally get increases in your stock that are up, that modify your original stock incentive plan? I don't know.
You can.
You can? Okay. And then outside of that, what happened in Chisholm wasn't that, it was bonuses, so it was more kind of a typical sort of salary negotiation, but in the form of a bonus. And see, that seems silly.
I do think of these, it's interesting to explore these, but I do think like to Raquel's point when she said that HR would be involved, you're also going to have a CEO, there are other human beings who are there. I don't think it's either 1.5 or 1.8.1, but I don't think it's necessarily either. Could be neither, I think.
You think it can be neither?
I did.
Okay.
But not if we're just going to say it's a standard client, because then we're just saying the
I
client
don't
is.
think that they're standard because they have these
Yeah.
other departments, these other people, even if
Right.
it's a 3-person thing, there's an owner.
But I like functionally agree with you, but we're kind of like within the
Blending.
RPC, we're saying here's a client who's so sophisticated, 1.8 doesn't apply.
It's like saying like nothing applies,
Right.
you're above the law.
Well, it's really,
Well, that's
and
how
you
it's treated
understand-
right now, but that's a separate question.
we can understand why the
Not
courts.
right because nobody complies with it. If they
Right.
should, they should.
But it's interesting to see how like it makes sense to me why the courts want to say these rules don't apply.
Yeah,
But do we agree?
the only case that I found is Washington. But then there's the California cases that have to do with, forming a business with your client. And then there's the one about the contingency fee that I took out because it has nothing to do with 1.8.1, but the concept is, the court said that the contingent 6147 applies to in-house lawyers. So the lawyer had negotiated a contingency fee. He litigated the case. He negotiated a contingency arrangement with his employer. And when the employer reneged, they sued. And the court said, no, you got to put it in writing. You got to have it signed by the client, and it applies to you just like it applies to everyone else. And so, the court really did treat the in-house lawyer like any other lawyer,
It makes more sense in that context, right? But it's very tricky to see because on the one hand, everybody here, I think, would say that something applies, but it's also somewhat different
Right.
than what I do outside lawyers, right?
Yeah. Well, yeah, but
Even when I'm going up against, even when my clients are sophisticated, they might not know anything about this thing or whatever, and that's what the rules are designed to protect. So should apply to them. On the other hand, nobody thinks that.
I know. Okay, so but then how do you formulate an opinion? Basically, that's the struggle. So maybe we
Tell people
scrap the
this
whole
is what
opinion.
they're doing.
No. I think this
Okay,
will be a challenge, but it's a great opinion.
All right.
what you said on this, Ken, I mean, with this 247, I guess that's kind of interesting, because if we're treating it as a fee, as
The
opposed to a
contingency.
salary, and
Right.
6147 applies, then
So does 1.5.
what about, and 1.5, why doesn't 6148 apply if it's just not a contingency?
It's just
It's
An employment
You're saying
agreement.
you have, I mean, I
Or
guess you'd
salary.
have, I guess you'd have to have an employment agreement that complies with 6148. And
See-
I guess unless the exception for corporations kicks in, but.
I don't think the labor code permits contingency wages.
Really?
Does it?
I don't know.
Well, I mean, it doesn't apply to attorney.
Yeah, I don't think so.
I don't think you can be
Yeah,
like,
right.
hey, guys, build these cars and if they sell, I'll pay you. I don't know if you can.
Oh, I see. Right. The contingency part of it. Yeah.
But-
Yeah. It's not a,
Different than selling.
well, no, yeah. Sales commissions is a continue.
Oh, yeah, right, that's not what I meant. Yeah, you're right.
Pay them.
Yeah.
I mean, is your salary a fee? I mean, look, you
I
can
think-
that
With the firm, like your salary with your law firm. Yeah. No, because
Or
you don't
no,
have a client.
If you're in-house counsel, is your salary a fee? They're
Well,
your
that Chisholm
client,
says no,
they're paying you.
but there's nothing in California
One
that's,
point five applies, that applies to fees.
I mean, we're really
Not
getting into
salary.
like, well, how come nobody's answered this question?
Right.
before?
But honestly, like, I think
Article not
Can't do
address
both
it?
salary and-
this is Brandon. We learned that Hollywood was like, all these entertainment lawyers had no fee agreements. They had contingent fee agreements and that weren't in writing, that there was like a whole industry built on this until a judge in LA said that
When was that?
like 5 years ago. It was a Johnny Depp case, actually.
Oh,
And like the entire entertainment industry was running on these like handshake deals. I get.
oh yeah.
And like all the law firms freaked out.
Yeah.
And that was a decision that sort of addressed a whole industry that was acting a certain way.
Right. So we can address that.
Okay.
Okay, so, and I know I keep, at every meeting that we discuss it, I'm like, okay, so we like open up a whole new discussion.
Right.
But, so I do need to narrow it down and I need to be more disciplined about focusing and just getting it pen to paper.
And this is Sarah, and just because I know it's now 4, and I realize the civility amendments took a lot of time. But because I know we're not going to make it through, obviously, the entire agenda, I wanted, and towards the end is new topics discussion and new member assignment. So I just wanted to also say that I think we have 3 people currently on this working group. So we could add one other person if anyone is interested in joining this working group, because I do think this is a complex issue. If anyone is interested, we would welcome it, I'm sure. So
I'll do that, yeah.
Yay.
It makes my head
Or,
hurt.
well, you too.
Well, I'm afraid I'll make it worse, but if I can be included without putting us over a quorum, count me in.
Okay,
is that doable? That'd be great.
yeah. And I'll try to coordinate. When's our next meeting? This
So who is it that volunteered for this committee? Sorry, I can't see you guys, so,
It's
Dan
Anna O'Reilly,
O'Reilly.
Brandon.
okay.
And Raquel, I mean, with your business background, you might be, I mean, maybe you can just review the draft from just more of a practical business perspective. You know what I mean? Like just we're lawyers, we don't.
No.
Yeah, I mean, if you don't mind,
Okay.
yeah, no pressure.
There's this fiction that the lawyers are the more sophisticated person.
Oh, we know nothing.
I think we wrote that.
Should we write it? We should script.
Okay.
I hate not to be flying white, but there's how many people are on that subcommittee now? Is that gonna be a badly keen
It's
issue?
5.
Is 5 okay?
5 is the max.
It's so 5, it has to be less than a quorum.
Oh, but when we were on the field, we were all told 3 was the most we could have on a subcommittee.
1, 2.
But this
I
is a
think we have
working
too many.
group, so it's
Yeah.
volunteer based.
Oh,
Not a subcommittee.
Yeah.
oh,
good, okay.
That's it, it's a working.
Yeah, so
group.
if
Working
it is
Gotcha,
a
okay.
group appointed by the chair,
Yeah, it's
a formal appointment, that's a subcommittee and it is a 3 or more issue.
Oh, okay.
So this is whatever you can give, as far as your time and expertise.
And Cassidy, I'm sure December 2nd.
Okay, second, okay. All right. No, I'm fine. We can talk to 1.7,
We
but
can skip the flat fee one unless anybody has any comments. Because it needs more work. I was gonna get another draft, but I didn't get to that. So unless anybody has any specific comment, we can pass that on to the next meeting. I work with the working group, excuse me.
I had some comments, but I had some comments, but some of my comments are probably just because I think near the end it wasn't complete, right?
Well,
It's-
definitely not complete.
Yeah, okay, so I think, but I'm just looking at the agenda. Okay, so the next on the agenda is the flat fee and termination. which I understand is still a work in progress, so might benefit to postpone to the next meeting. We also have the updating the opinion on the bidder review and fee disputes. The attorney is expert witness in handling of retainers and fees, which, Cassidy, did you take the lead on that one? I don't want to put you on the spot.
Yeah,
Right.
I just, it's not that, we could cover it if you wanted to outline, and Joel and I worked on it.
And then the other one is, just because we only have a half hour, I'm wondering this is what I propose, we move to the agenda item on cryptocurrency, because I know that will be a pretty short discussion. Or we move to the agenda item on client file release and retention duties, because I understand there were some public comments that we could get a summary on. So the people on, I'll just open it up for the people who are on those working groups to see who would prefer to kind of take the last spot on the agenda.
I'm fine with that on the client file retention.
Okay, I think that makes sense then, since we did just recently receive some colorful comments, so.
Yeah, let's do that one.
Okay, so there were a number of public comments that came in. We kind of classified them into general piles. The most common was people who submitted comments, and I'll say, and I don't think I'm being unfair in saying this, but essentially did not read any of the nuance and did not really read any of the exceptions or qualifications of the opinion, and just look at the notion of maintaining client files for the life of the client. And the primary concern was that's such an onerous burden on attorneys. There were lots of different comments as to what that includes. It may include it's difficult to find clients who you need to give their stuff back to. It's difficult to find out if clients have died. It's difficult to pay for storage costs. It's difficult to pay for making these things electronic. There seemed to be some confusion from some of them that they believed that they didn't have to be doing that already. This opinion is actually something that references an earlier opinion that already said life of the client. If anything, this shows how to reduce the burden, discussing how files can be made electronic and stored that way. Generally speaking, I think that one of the public comments that was ostensibly in support of, but realistically requesting a modification of the opinion, that opinion or that comment dealt with those other public comments adroitly and basically pointing out that client file retention and storage is overhead. That's really what it goes to. And the comment that did that was from the appellate projects, CCAP, the California Appellate Project, and a couple others, where they said, look, this is overhead. This is what it costs. We have plenty of lawyers who do this. They're expected to do this. And that was notwithstanding other comments we had from attorneys who accept appointments saying this is very difficult. The opinion itself already deals with that. It says, look, this is their property. It's not about forcing you to maintain it for your entire life or the client's entire life, but it's making sure that the client gets their property back. So the vast majority of comments, I think, are already dealt with the opinion. Then there were some opposition comments that essentially didn't really add anything. They were just, I think this is bad policy. And a lot of them were suggesting that there be a rule somehow or some kind of legislative enactment that had the state bar either funding or actually itself managing client file retention. And that's really not our purview, so we won't be addressing that at all. The support and modification, I think, really was concerned about making sure that it's clear in the opinion what an attorney can do. It can set up a fee agreement or a retainer agreement that includes disposition of those assets of the client's file, that includes the ability of electronic storage outside of the exceptions of specific documents. The one that I thought may require some additional follow-up and actual research was one that discussed estate planning documents themselves. Now, I would have thought that those originals would have fallen within the exception of original documents that are the property of the client and cannot be scanned electronically. They had to be kept. That being said, I'm going to have to do a little bit of research on that. That was the only comment that I thought had something to say that I did not have an immediate response to.
Well, I think that's good. Those are, I mean, I don't do estate planning, but those are original documents. And just from malpractice cases dealing with estate planning, you need the originals, at that time. So, many lawyers agree with their clients that they'll hold them, others don't.
But you have that in here, right? I mean, that,
Yes.
We had a lot of this, throughout this, we had, like, at one point I counted how many times we had in here,
probate code, the probate code.
absent, things, other than agreement by a client, or is required by a statute. We had those exceptions in there multiple times.
What I would propose.
What we talked about was whether they were clear or not. I mean, we thought they were pretty clear, but based on these comments.
If we're getting, 10, 15 comments that say, I can't believe you guys aren't allowing for any exceptions, then maybe I haven't been clear. So I would propose to go reread the opinion and try to do that with fresh eyes and ask myself, have we made it clear that this opinion is not just saying, hey guys, you have to keep everything forever? That it's clear that this is about the property of the client and that we're drawing those distinctions and making it clear that electronic storage can be done when appropriate, that files can be returned to the client, should be taken care of in agreements, things of that nature, just making sure that's clear.
And Hunter, how many comments reflected kind of a lack of clarity on that point?
Well, they did, I think I can answer that. It wasn't so much they reflected a lack of clarity. They were all just saying, I would say the majority of the comments said these provisions requiring you to maintain client files for X amount of time and even more in the criminal, it's just too expensive and too burdensome.
Okay.
They didn't talk about, the exception. So, and our point was there, it says in there, absent an agreement, you can't agree with your client, blah, blah. We had that, I think it was at least 6 times we had that in there. So I thought it was very clear that you can, and I think at one point it says in there, I mean, you can agree with your client in the fee agreement, to give them, you don't have to keep the file. You can give them back at the end.
It seemed almost an issue of, you guys have probably seen the pervasive issue of somebody posts a news article on social media, somebody reads the headline and responds. I don't want to suggest that people aren't reading it, but it did seem that a lot of the commenters were taking away a very narrow vision of the opinion, that when you read the entire opinion just isn't a legitimate reading of the opinion.
I understood. And this is Sarah. One suggestion I have, just to, maybe it's already in there and I apologize that I didn't review this right before this meeting's opinion again, but I have previously, and to the extent it's not already in the digest or the upfront summary, perhaps you can make sure it's clear there, because people are obviously going to focus on that, or maybe even focus on the conclusion. So to make sure it's clear in maybe the intro and the conclusion for people who don't carefully read the entire opinion. It might already be.
Right, and that's what I would propose to do, that we go through it and just, because we'll focus on a footnote for 2 months.
Yeah.
And maybe not everybody does that.
They definitely did.
Who else is on your committee, your working group?
Ken and Justin.
Hey, Justin.
I mean, we do have absent an agreement in the digest, but I guess we could, expand upon it, make it clearer. But it seems like from reading those, we almost have to, it was almost like, looking for a practice pointer, you can put, something affirmatively, you should put this in your fee agreement with your client.
Well, did the commenter, were they, because I get a lot of clients, elderly clients and clients who's taken over practices and they're like, I have all these files. All I want to do is destroy them, And that's what the fact pattern is, right? And so maybe they're like freaked out.
And they are, a couple of them said things to the effect of, well, like, how am I supposed to track these people down?
Right. That I always get that question, and it's like, do your best.
Yeah, and that's kind of the reality of it is, well, don't lose track of your clients.
Right.
And sometimes it's not possible, right? There are people who go change their name, die, that these things happen.
Well, it just says, now it says, you have to make a reasonable effort. So,
Right.
if you lost track, you can do a Google search or, keep track of what efforts you made to find the person. And, if you've done that, you haven't heard from them in 20 years.
And it's something that you can put in the agreement. I'm going to search your home address. If you change home addresses, let me know, because that's where I'll be looking when I go to give you back your file.
Right.
You're not there.
Yeah, I
can see why they don't give them back right away, because even to do that, right? And that has its own expense.
Yeah. I mean, well, that's the risk management aspect, keeping it for yourself.
Right.
I mean, I've seen figures and or it's in the rules or so, it's in there somewhere that you can, at the client's expense.
Yeah.
If you have it in the fee agreement, you can retain the copy. Or digitize it now.
Right. We still have a couple $100 somewhere. South San Francisco.
My old friend.
So I think you've kind of summed up, Hunter, the action item for the next meeting, right? So it sounds like you'll kind of look at it more carefully, just see if there's any additional clarity that could be added that's not already in there, and then propose if you think it's appropriate edits, red line edits for our next meeting. Does that sound like a good plan for the working group?
Yeah, it was the only other one we discussed was one of the comments. But I think it was already we discussed it in the opinion. In criminal cases, there are certain things that are in a file that you cannot give to the client.
Right. So 1054.2, and this is just something that I happen to know, is that there are limitations on what you can give to a criminal defendant in terms of information. Part of this has to do with the victim's rights, Bill of Rights. It's laid out pretty clearly in 1054.2. I may input something in the opinion that basically says, if they're not entitled to it, then it's not their property under the typical concept of their file. So those things would have to be redacted when provided to the client.
Yeah, we touched upon it in the opinion as it exists, because we talked about how there was the new comment to 1.16, and that new comment cites those code sections. So we talked about maybe just throwing in a footnote to make it more clear, because right now it talks about there's a new comment. But
and it may be, and I was thinking about where to put that. It may be that in the, what does a case file include? Maybe put a footnote in there that, in the context of 1054.2, it would not include in a criminal matter the name and telephone number and address of the victim. Name the victim.
But does it include college and so?
God, that seems like so long ago.
So I think, did the working group want to talk about any other public comments, or do you think you covered it?
I think I covered it pretty well.
Okay, thank you for that feedback. And I think we're at 4:15. The only thing that we might have time to do, if the working group wants to do this for the cryptocurrency opinion, I know there is one discrete issue relating to a recently issued ethics opinion by Ohio that addressed cryptocurrency And maybe we could talk for just 10 minutes, if that's feasible.
Yeah, I mean, I think that
And then-
works.
Okay,
This is Bill, and Eleanor and I were kind of the leads on this opinion, and I submitted a draft. I think was it may have been talked about last meeting. I wasn't here, unfortunately. But one of the issues that really Eleanor and I struggled with was this idea of safekeeping the cryptocurrency, because it's not money that you can put into a trust account, and it's not regulated. So what if you're going to, and that's where we kind of, can you do it or cannot? It's really in the context of, advance fees, or you taking a retainer and you're going to, work towards that as we would do in a typical case. I get a $10,000 retainer and I work from that, going forward for future legal services. How do you do that with cryptocurrency? Can you do it? And I think our initial thoughts were, given the safekeeping issue, you can't do it. And I don't know if you can't, because these other opinions suggest you can if you take these steps. And my thought, and Eleanor can chime in, is it's probably more of you shouldn't do it as opposed you can't do it. I mean, and that's not where we want to go, is to say you shouldn't do it. It's either you can or you can't, right? But I think for our purposes, we want to get some input from you guys as to what your thoughts are on the safekeeping issue. The Ohio court, or not Ohio court, the Ohio bar, they addressed the safekeeping issue, although they didn't go into much detail about it. So, and none of the opinions you really have, they just say that's an issue, and it kind of scratched the surface. And I think one of the things that Justin had said before is, how do we stand out in California from maybe these other opinions? And I think this is really the one issue where we can stand out, because the only other one that I've read is Nebraska. It says you can't do it. You can do it. You can accept cryptocurrency for past services. I send you a bill for the $4,000 of work I've done. Yes, you can accept cryptocurrency for that bill, but you have to convert it right away to fiat currency. In that situation, it's okay to accept, and I agree with that. It's just in the context of advance fees or retainers, can you do that? And I think that's really problematic from the lawyer's perspective, because you can't account for it. I mean, what happens if you? It's irreversible. I mean, if it's lost, it's lost. You're done. You can't get that money back. Is it going to be covered by a cyber policy? Is it going to be covered by your LPL policy? As the lawyer, because typically lawyers get sued for the client wants their money back. That's basically disgorging the fees. They're not going to pay. That's not going to be covered under an LPL policy, generally.
I'm really curious, is there some reason, I agree with you that obviously you can't put it in a trust account. Is there a reason you couldn't?
Love you.
Take cryptocurrency as an advance fee deposit, and then with the agreement of the client, whatever you do, convert it to fiat or however they call it in here, and then put that in trust?
Yeah, I think you can do it. And I think, and Eleanor, chime in if you want. I think one of the issues we had with that is there is some lag time between receiving the cryptocurrency and converting it to fiat. So therefore that would trigger 1.8.1 as a business transaction with the client. So as long as you do that, comply with 1.8.1, I think you're okay. But I think that's a safe route. I mean, if you want to accept cryptocurrency for a retainer, convert it to fiat currency right away, comply with 1.8.1, then you don't have the safekeeping issue of trying to figure out what the heck you're going to do with this cryptocurrency. That's some electronic form somewhere, someplace.
You can't see.
Yeah.
Or at least you don't have it for an extended period of time, but arguably you do have it when you accept it and hold it and transfer it to a conversion entity.
So
Is it a foreign currency, really?
Well, I guess
Sorry, I couldn't hear that.
currency regulated in some context, I would imagine. I don't deal with foreign currency, so I'm not too familiar with that.
But the conversion process, like if you get paid in English pounds, there's still a conversion process. It takes a couple of days, similar to that,
Right.
I think.
But I think one of the issues is that the fact that cryptocurrency is not regulated and is not money. I think that may be a distinction, whereas, a pound is.
It's a security.
Yeah.
But it's not, it's not
Okay.
quite regulated. There's an opinion that just came out, I think. And I don't know this, anyway, it's the Wild West, right?
Yeah,
So,
it really is.
So convert to something that isn't the Wild West.
The existing
Exactly.
rules on fees really all contemplate that you're going to put it in a trust account. And if it's property, which is how it's treated by the IRS, the rules contemplate that you'll keep it in a secure location, such as a safety deposit box. So there is nothing equivalent to that we're aware of for cryptocurrency. I think that's where we're a little stuck. I don't know how you're feeling, Bill, but I would really invite the involvement of someone who's got a background in fees for a discussion on this, maybe as a subgroup.
Yeah,
We can.
no,
Go
I
ahead.
don't no, go ahead. Yeah, I agree.
So you really need to find out what the constitutional framers meant by place of safekeeping.
Exactly.
I would guess there's something to the person who pays in crypto. And maybe you're saying that, you don't want to adopt the Nebraska solution, which is just make it US dollars and hold it that way. And I don't really know exactly where it is held, except in Ether. But you're not going to get out of the rules that you have to hold on to it. You can't hold on to it that way.
Right.
So what else is there?
Yeah, that's the struggle that we've had. And I mean, I think Eleanor and I on the same page here, at least, is that you can't do it. I mean, I think if you technically, how do you say keep something that really doesn't exist? I mean, it's air. It's just what someone believes.
Or do you get a key? I mean,
You have a wallet.
Yeah,
You
a
have
wallet.
private
Like a password,
public
right?
wallets that are blockchain.
could be safeguarded.
Yeah, I mean, if
I mean,
it's
I-
encrypted and things of that nature, yes.
I think it's because it's a fee and the way that the rule discusses safekeeping of funds that is challenging. Like escrow is what the Ohio court deals with, or the Ohio opinion deals with, and I can see how they land where they do. It's not fees, it's holding something in escrow. Arguably, you can apply a reasonable standard there, but I think when it's fees, the obligation to safekeep is higher, and the rules are more specific.
Safe farming, I hope the crypto.
At least that's how I read them.
the whole thing goes away, frankly.
Yeah.
And I agree with Eleanor that this is Justin. I don't think this Ohio opinion gives us enough guidance. Unfortunately, I think we're still, because it says, and it's the first footnote, I mean, this is limited to lawyers holding crypto in escrow and not for payment of legal services, whereas our opinion is about payment for legal services.
They
So-
took they did all of this discussion, so let's take the easy road.
Yeah, exactly.
Yeah, let's not address what we really need to address.
That's
which is payment of
exactly
legal
what
fees.
happened.
Because in LA County Bar Prep, I mean, I still have PTSD. I was on the subcommittee for crypto for, I think 3 years, 2 years. And we could never come to consensus. We do have 40 people on that committee, so it's a little harder. But I mean, we spent hours and hours and days going in circles on these issues. But as time goes by,
It's happening more and more.
things are changing. Some countries are adopting crypto. Some banks are starting to say, yes, we will safekeep crypto. So I think it might just be too soon. Even though lots of things are happening and people are issuing opinions, it might be too soon because things are developing so quickly.
But they are accepting fees. I mean, I was just talking to an insurance client and they're like, what's going on with crypto? We exclude it. You know, if their insureds accept fees via crypto, they don't insure. It's a question on the application.
Wow.
But they want to know, like how is this emerging? Because we don't want to have to do that if there's a safe way of doing it. So.
Yeah, I mean, it's it is the wild, wild west, but it's here. It's here to stay, I think. I don't think it's going to go anywhere. And I think the feds have got to figure out if they're going to regulate it. And if so, how? I think once that happens, then you can have a maybe more firm opinion, and there is the ability to properly safekeep it within the context of the rules. And that would certainly be a footnote in the opinion. Is obviously this is going to change because this is an evolving industry that
I don't get it, honestly.
Payment for fees rendered, it's easy.
Yeah.
What do you need? I mean, you don't need anything. really.
Well, can you pay with Beanie Babies? I mean, that's kind of like,
Pardon me?
can you pay with Beanie Babies? You know what I mean? Like
Yeah.
it's,
It's not even a meeting, it's like
They
something.
could
that
if the
leads to a
lawyer
meeting.
accepts it.
yeah.
That's the wallet is like a key to its
Yeah, so
feature.
I'm not understanding why you think the wallet is not a secure, acceptable storage, safekeeping location.
Well, one, my concern is it's not regulated.
Okay, well,
And that's one thing. That's one thing for sure. I mean, I guess I can go both ways on it in the sense that, I mean, how's it different than your computer? You have electronic files on your computer, you have encryption, you know, other various methods to protect that information. And maybe that's the route we go, is it just kind of double encryption or whatever.
So it's like the cyber, it could be
Suppose
like a
the lawyer
hybrid of the
dies.
cyber rules, you know, like you have a duty to know what the security, cybersecurity options are for protecting, you know, those opinions.
Yeah, it's certainly a competence issue. Yeah, absolutely.
Right.
Definitely.
Yeah.
Crypto
But
is
I think,
more
I mean,
secure.
one of the issues with the wallet, sorry, go ahead.
I was gonna say, crypto is more secure than anything. And you can do a lot of things to personalize it, and so it's actually
I don't know if it's secure.
I'm not sure about
through the
that.
blockchain.
Yeah.
So I mean, so that's why I'm wondering.
There's a lot of,
Well, there's a blockchain that just got hijacked. And
Right, exactly.
they
That's-
manipulated the chain. I mean, but that's not why we're coming down here. I think for me, the concern is, I mean, there are multiple concerns that we've raised, but one of them, when you're asking about the wallet, if you have the key to the wallet, you have access to the funds.
Who has
And
the
so
key?
what if-
You're the
The
client.
owner has the access.
The owner has the
It's
key.
only the owner has the key.
So like you would be
Right.
the.
So let's say you're the lawyer and you have the key and you die, and so someone else has the key too, and so you have to disclose. I mean, they're just interesting issues. There's a multitude of different issues that make it less secure and more difficult to safekeep because of the lack of regulation, et cetera. I'm not saying that's, you know, it removes it from the realm of being able to secure it, but I think it makes it more challenging, and it certainly doesn't fit what's provided in 1.15.
Is it too analog just to say converted into US dollars? You know, that
That's
was
easy. Yeah.
Yeah, that's easy. If our purpose was to provide guidance in terms of, here's we would recommend that you do A, B, and C as a lawyer. Maybe I don't think that's our role. At least that's my understanding. Then it would be, my recommendation would be converted immediately upon receipt, and then you don't have to deal with these issues.
It sounds more, this is Hunter, it sounds more, it doesn't sound like best practices advice. It sounds like since you have to follow this rule and you can't, you have to convert it to some kind of currency that allows you to follow this rule.
Yeah.
I think that's actually the good approach is that right there. I mean, I didn't think about that. I mean,
But they don't want to do that. The lawyers
They
don't
don't,
want.
because they want to be able to
You
have.
want it to go up. Right.
Yeah.
So you don't want it to-
Yeah.
Creates
Well,
other
it's-
issues.
But it's no different
that's
than
the
others.
issue
That,
there.
in that respect, it's like stock, you know, I
Exactly.
mean, it's the
Yeah.
But
thing.
it's not regulated. and
Right.
it's-
Yeah,
But this,
Yeah,
this,
and so the
this
people
triggers
who
the
are
trust
using
accounting.
it
rule.
are very
Yes.
comfortable with it.
absolutely.
Yeah.
That's the thing, I mean, the trust is written, it's
No.
gotta be, it's a trust bank account.
So
you're an
they
arms dealer.
I actually agree. with
Yeah,
her.
because they
I haven't had a chance to
know
speak.
how to secure it and who has the key. I mean, it's not.
But I think the problem, I don't think we can do that under the current trust accounting rules, because
You
those,
probably
those say it's gotta be in a bank account.
Right.
So,
So, you
yeah.
know,
Funds have to be in the bank.
Yeah,
right?
well, you have to deposit
But if
the
it's
advance
property-
fees into a trust account, which is
But if
a
it's
bank
property
account.
and not funds, you don't have
Safeguard.
You
to.
can't do that.
It doesn't.
Place of safekeeping.
Safekeeping,
Yeah.
safekeeping.
Right.
Right. Doesn't say.
But it says, so other place of safekeeping. I think
Right.
the question is, what does that mean?
What does that
And
mean?
is that possible with crypto?
Yeah. And this is Sarah, the one I liked, Bill, you were drawing the analogy to like computer security and other measures, right? And I know in prior ethics opinions, we addressing kind of virtual law offices and other things.
Yeah.
We declined to specify particular security measures that must be taken in every, to properly comply with your duty of confidentiality. I know this is a different, we're interpreting 1.15 here and safekeeping. But to me, it's similar, and I'm hesitant to necessarily conclude right away. I need to think about it more, but like that you cannot safeguard cryptocurrency, that there aren't effective measures. I personally just don't have the technology background or understanding enough to understand if it's possible. I get the regulatory issues that you've raised, but I think it's worth considering more.
Can an attorney and a client agree that the client assumes the risks? Like the client wants it in crypto, and I'm a client who really understands crypto, and I understand all the risks, or is that an improper assumption?
This is Hunter, and one of the.
No, I mean, I think that's where we ultimately started, and I think we've just struggled with whether or not that's appropriate with respect to fees. But Bill, I mean, that's where we were originally. It was like, okay, as long as everyone understands it, it's more of a competence issue and disclosure and informed consent.
Yeah, that's right. That's because we went through that analysis. It's like, okay, if you're going to do that because of the fluctuations, what do you have to disclose to the client? And who's going to bear the risk if 1 month it's up here and then the next month you send the client a bill and for 10,000 and that crypto's now at 2,000.
Right.
That's all got to be disclosed.
Because even the recommendation that I had, which is essentially just tell them you have to convert it to cash, what that would do is exclude people who have cryptocurrency to use to pay for legal services but don't have cash on hand. That would essentially exclude them from being able to pay for legal services, which is problematic.
And are there tax implications with all the
There
different
I follow
versions?
that.
Very much so.
It's not as simple just convert it again. There's 2 tax penalties essentially associated with double converting it twice.
Right.
So this is Sarah.
Did you
and
hear Eleanor? I think she said she couldn't hear. Did you hear us?
I just missed one of the comments. I think it's okay. Thank you.
This is Sarah, and since we're after 4:30, and I think our meeting's supposed to conclude at 4:30, I'm so happy that we've had such a great discussion at our first meeting, and that everyone, including the new members, have contributed so much. So I really appreciate that, and we'll try to catch up on some of the other items at our next meeting. But I think we've had some great discussions and gotten some great feedback on what we were able to reach. So thank you, everyone.
Good
Can I
job, Sarah.
just add something before you guys leave? If you guys had agenda items for this meeting that were not discussed and you plan on not revising them for the next meeting, please let staff know so we don't just assume it, whether we should, so we know which way to go, whether just a repost or whether to wait for you to provide them.
All right. Thanks, Mimi.
Thanks.
I think we're done.
Yes, we can adjourn the meeting. Thank you.
Thank you, Sarah.
Unless